All right, good morning. We're here for the continuation of this oral argument session for the 6th District Court of Appeal. The next case on our docket is 2024-0451, Cisnero v. State of Florida. Counsel for the appellant ready to proceed?
Yes, sir.
Counsel for the appellee? All right. Sir, if you can come approach the lectern. And sort of the standard time, if you will, is 5 minutes for rebuttal. Do you want to deviate from that?
Yes, Your Honor. I'd ask to save whatever time I have left over, please, for rebuttal.
Is 5 minutes sufficient?
Yes, sir.
Okay.
It should be.
All right, thank you.
Right.
All right, go ahead.
First off, let me thank the court for allowing me to be late. I apologize. That doesn't happen very often. Before the court is Cisnero v. State 24-0451. I represent Mr. Cisnero, who is the defendant below and the appellant here. Mr. Cisnero was convicted of conspiring with others to cause trafficking in amphetamines. And the evidence was not sufficient to convict him. Mr. Cisnero, through counsel, of course, moved for a judgment of acquittal. That motion for judgment of acquittal was denied. So that's where we are right now. The evidence against Mr. Cisnero was voluminous. It was set out in the initial brief in some detail, and I thank the court for allowing me to file a extended initial brief. I went through all of the evidence against all of the material evidence against Mr. Cisnero in the initial brief and explained why each item was not sufficient to support a conviction. The evidence fell into really two categories. There were a number of, text messages, and there were a number of wiretapped conversations. Now, the speakers in the text messages, or the writers, I guess, in the text messages, were identifiable. But there was nothing in any of the text messages that pointed to a conspiracy to traffic. There was some material in the text messages which suggested that perhaps Mr. Cisnero owed some money to an individual named Adolfo Magana, who was one of the other alleged conspirators. But of course, owing money to somebody is not sufficient to establish a conspiracy. There were also voluminous recordings, and in the recordings, all of the recordings, these speakers were not identified. The speakers were shown in the transcript to be, quote, unidentified male speaker. Well, that certainly should have drawn an objection or many objections. It did not, but that's a different issue for a different court on a different day. The real problem here was without knowing who's speaking, it's not possible, really, to identify what the defendant may have done or may have said. If we don't know who's speaking, first off, that's probably not admissible.
But counsel, wasn't there testimony at the trial as to people recognizing your client's voice?
Well, people identified my client. There were people who said that they identified my client's voice, at least one witness. But that doesn't solve the problem of who's speaking. In order for the jury, or for that matter, for this court, to discern whether or not a particular person made a particular statement, we have to know who the speaker was. And here we do not.
I'm sorry, maybe you lost me for a second. I thought you just said there were witnesses that testified, there was testimony,
Yes,
that if believed by the jury, they could conclude this voice that I'm hearing is the voice of your client, correct?
no, Your Honor, that is not correct.
That's not correct.
The witness testified that he, I think it was a male, that he recognized Mr. Cisneros' voice. But the witness did not testify that the first speaker or the second speaker was Mr. Cisneros. We know that Mr. Cisneros was part of the conversation. And in fact, most of the conversations were simply gibberish in that there is no good way to decipher what was recorded in the transcript as indiscernible. The transcriptionist, whomever made the transcription, I'm sure did the best she could, but apparently was not able to identify who the speakers were. And the transcriptionist
But
was
you would
not.
agree, just because the transcriptionist, the court reporter is unable, doesn't mean the jury's unable to recognize the voice, correct?
The jury was not familiar with the voices.
Didn't the jury have an audio recording of your client's voice? That
There
was
were
definitely-
many audio recordings that may have included Mr. Cisneros' voice.
Wasn't there an interview with law enforcement?
Believe there was. But the problem with the trial and the problem with the transcript is that the speakers in the transcript were not identified. Now, without knowing Mr. Cisneros made a particular statement, we can't attribute that to him. The jurors
Counsel,
presumably
if-
heard
if,
exact.
Counsel, if I may, so there was a witness that testified that he recognized the defendant's voice, but he didn't specify which voice was the defendant's. That's your,
That's correct.
okay. Could that witness have discerned the difference between Cisneros' voice and the other male voice?
I don't know. The witness, that was
So-
not,
so
that
by
was not
not-
in the record.
So by not timely making an objection or raising this in the lower court, how on appeal can we look at this as an error when defense counsel didn't raise this to the lower court where this could have probably been fixed at that time? Simple fix, who's who, which voice is which? Why should we not attribute that to your side of the fence, if you will?
Because to do that, it would be necessary to attribute certain particular statements to Mr. Cisneros. We would have to assume, without knowing, that a particular speaker was in fact Mr. Cisneros. Now, we know Mr. Cisneros was part of the conversation, but we don't know whether Mr. Cisneros was the person who said, "I owe you money," in so many words, or the person to whom the money was owed. And of course, that could be either of the people. So we need, in order to get past a motion for judgment of acquittal, there has to be some statement in some conversation by Mr. Cisneros to the effect that he was involved in trafficking in amphetamines. There was no such statement. Now, there were some interpretations by law enforcement officers. One of the officers, I think two of the officers, testified as to the meaning of certain words in the transcript. But in at least one situation, the words in the transcript that the officer was asked to identify were in fact not in the transcript. Why the officer was asked that question, I don't know. But the officer was asked, perhaps the prosecutor thought that something was there that was in fact not there.
Counsel, if I can interrupt, I believe you're referring to the bumpy road in one of the conversations. You're correct, that was not captured by the court reporter during the trial, but was it not in the transcript that was provided to the jury for their consideration regarding the recording?
Well, I do not know for certain what was provided to the jury. That's not part of the record. I wish it were, but it's not. And without knowing what the jury saw, I can't answer the question. I have no way to know. Now,
Well, counsel, I mean, the exhibits are certainly part of our record, including but not limited to these audio recordings. The
Yes.
actual recordings, not just the
Yes,
transcript, but
that's
the
true.
recording itself.
that's true.
Those went back to the jury, I presume?
I don't know.
Okay.
I don't
Doesn't
know
the
why.
record
I don't
reflect that
know.
all the exhibits went back with the jury?
My guess would be that the audio recordings that were made part of the record were the recordings that came from the court administration. The recording system in the courtroom would have, excuse me, would have picked up everything that was said in the courtroom, and that would have been the recording that was used to prepare the trial transcripts. We did not have or they did not have, I wasn't there, they did not have a court reporter sitting in the courtroom taking things down. This was done by an audio recording. I assume, again, without knowing, that the audio recordings that the clerk put in the record were the audio recordings from
No,
the
I'm sorry,
court
counsel,
administration.
if my question was unclear. The exhibits, the actual copies of the recorded phone calls, et
Okay.
cetera, any audio recording that was admitted into evidence as an exhibit, those actual exhibits are part of our appellate record, and they were admitted at trial
Yes,
to
they
be
were.
considered by the finder of fact. the
They
jury,
were.
right?
I do not know whether the finder of fact listened to those recordings.
But that's
But-
not our question, is it? Do we have to have evidence as to what exhibits the jury actually listened to or looked at? Or are we to presume that they could have looked at everything in evidence and considered everything in evidence? The testimony, the documentary exhibits, the audio recordings, isn't that our obligation?
Yes. If the jury listened to the recordings, the jurors were certainly not familiar with the voices of the speakers in the recordings. The jurors could not have discerned whether speaker 1 was Mr. Cisnero or whether speaker 2 was Mr. Cisnero.
Why not?
They weren't familiar with the voices. We have
They had evidence before them that a particular voice on at least one of the exhibits in an interview with law enforcement was your client, correct?
Well, no, sir, not
No?
really correct.
Okay.
The witness testified that he recognized Mr. Cisnero's voice on the recording. But the witness did
No, I thought
not.
there was an interview of your client by law
Okay,
enforcement.
there was an interview.
Okay, so
But-
the interview, the jury gets to hear your client's voice, and they know that's your client's voice, correct?
Presumably.
And can't a juror then listen to that voice and listen to every other voice on every other exhibit and make a finding of fact that those voices are the same? That's within their province. They could also say they're different, but they could have said, this is the
Well-
defendant's voice.
That is possible. But when we review the evidence,
Who's we?
this panel and the attorneys, those of us in the courtroom here, when we review the evidence, we must work from transcripts. We, the attorneys, have an obligation to furnish a complete and correct record to the court. The court's determination of evidence or lack of evidence must be based on what's in the record. Here in the record, we have no indication as to whether or not Mr. Cisnero was speaking. So for our purpose, for the purpose of appeal, we must assume that the record is correct unless somebody's moved to correct it, and nobody did. So we do not know whether the first speaker in a particular conversation was Mr. Cisnero or was somebody else. Your Honor, I'm into my rebuttal time. If there are no other questions from the court, I would ask to save my remaining time for rebuttal, please.
All right, certainly. Thank you.
Thank you.
Ready to proceed, counsel?
Yes, Your Honor.
All right.
Good morning, Your Honors and counsel. May it please the court. My name is Allison Heim. I represent the appellee, the state of Florida, in this matter. At the outset, I want to address the record. I know Your Honor was mentioning the transcripts of the calls that were the exhibits that were given to the jury. Those are in the appellate record as paper. To my knowledge, they're not digital at all. And actually, during the preparation of the brief itself, we were unaware of the paper record. In preparation for the oral argument, we discovered the paper record, and so there are actual transcripts of almost all of the calls in the appellate record. These are,
I think those are 2A, 5A, and 16A. Do we know if those went back for the jury's consideration?
I am not aware if they actually went back, but I know for sure that they were published to the jury at the time the call was played. So at the time the call was played during trial, each of the calls, there were 28 of them. The call was played with the audio, and the jury was given a transcript of the audio to follow. In that transcript, it shows Hugo Cruz is talking. It shows when appellant is talking. It shows when Magana was talking. So the jury was able to clearly follow who was saying what. Even if they were not, even if the convenience of the transcript wasn't available to the jury at the time, the witness, which was usually Sergeant Taylor talking about the phone calls, he would tell the jury before the call was played, this is what the call is, this is the time it was made, here's who made the call, and here's who received it. So the jury was well aware for each call of who was speaking at each time.
In fairness, the transcripts themselves, though, reference Mr. Cisnero, or allegedly Mr. Cisnero, as UM, correct? Unidentified man?
In the trial transcript, yes. In the transcripts that were used as exhibits and given to the jury, which all of them were admitted without objection, all of those actually list Cisnero. I think there might be one that lists unidentified male. All in all, there were 28 calls, 19 of them, the transcripts made it into the appellate record. To my knowledge, the other 9 didn't make it for some reason, but the transcripts are here, and based on the trial transcript, the jury was given a transcript of each call contemporaneously with the audio. So with that, in reviewing the audio of the calls and the transcripts in the exhibits that we have here, it's very clear that the state met its burden and that the competent substantial evidence supported the trial court's ruling to deny this motion for judgment of acquittal. The evidence shows that count 1 for conspiracy pertained to dates June 10, June 17 and 18, and June 21. During those dates, specifically on June 10th at 10:15 p.m., after a series of phone calls and text messages between appellant and Hugo Cruz, which, just to take a step back for a moment, Hugo Cruz was the one of the heads of this drug trafficking organization. Appellant was someone who got a supply from Cruz and sold. in much smaller amounts. Appellant was identified after a raid of one of Hugo Cruz's stash houses in February of 2022. That raid revealed 76 pounds of methamphetamine. That's when law enforcement got more search warrants and were able to do wiretaps, pen registers, and vehicle tracking. So using those tools, they identified appellant. It's in that 10:15 phone call on June 10th. That is specifically when a final agreement was made that Cruz would supply a half for appellant in exchange for $1,500. I think that one was to be paid in 2 different installments. As soon as they got off the phone, Cruz then contacts his stash house guy, Magana, and says, I need a half of the cold. Magana says, sure thing. They arrange a time and a place to meet. Cruz and Magana meet. We know this because they agreed to meet, but also because vehicle tracker information shows that Cruz did in fact go to the meeting place at the time and place he said. They were observed by law enforcement. Surveillance photos corroborate that. Right after that meeting, Cruz meets with appellant at the agreed upon time and place and exchanges the half pound for $1,000 at that point. Then we have June 17 and 18. That's when Cruz comes to collect from appellant. He collects money in relation to that half pound that he was given on June 10th. On June 21st, Cruz does another collection. These are all corroborated by the vehicle tracking information as well as surveillance photos, surveillance video, and law enforcement who was at trial to testify to their observations. Then count 2 pertain to dates June 24 and June 25. On the 24th, there was discussion about appellant requesting more work and saying that he basically had customers coming to him and wanting more. And so he needed Cruz to help him out. He reiterated his loyalty to Cruz. And on June 25th, they ultimately agreed for Cruz to give appellant another half in exchange for another $1,500. Again, I think that was to be paid in installments by appellant. These were, of course, these meetings were all corroborated again by vehicle tracker information, and then law enforcement surveillance photos and testimony. And on the 25th, when the deal was made with Magana and with Cruz, Cruz waited at a grocery store. He was seen by law enforcement go into the grocery store. So he was identified himself. He got back in his car. He went and met Cruz. What these phone calls show and what the vehicle tracker information and the law enforcement surveillance and testimony shows is that on 2 separate occasions, appellant made an express agreement with Hugo Cruz to commit a criminal offense. The phone calls based and the actions of going to the agreed upon time and location shows appellant's intent to commit the offense. And essentially all of this is competent substantial evidence that does support the trial court's ruling denying this motion for judgment of acquittal. And if the court has no further questions, I will otherwise rely on my brief.
I believe it was Special Agent Taylor that testified as basically interpreted for the jury what the terms half meant.
Yes.
And he interpreted that as half a pound. And then the 600, 700, 500, he interpreted as dollar figures.
Yes.
Was there any record evidence beyond his opinion as to what a half meant to meet the threshold for the 200 grams requirement for trafficking?
Well, to meet the 200 grams, we have that he referenced a half, and that is 8 ounces.
Right.
And then there is testimony. I don't know if it's from Taylor or from Sergeant Harris later on, where they say a half would be approximately 224 grams.
Right.
There was some confusion over whether the second deal dealt with 7.5 grams or 7.5 ounces,
There was
excuse me.
discussions that they were going to short the appellant.
Yes.
Because he still owed money to Cruz.
Yes.
Okay. So that would have come in under 200 grams but is that necessary for a conspiracy charge? To have an actual amount, or was it the agreement to trafficking in an actual amount that's important?
Yes, Your Honor, it's the agreement itself. It doesn't matter if the conspiracy, the intent in the criminal act was even completed. The weight, the actual weight does not matter. What matters is, as you said, the agreement and the intent itself. And in both these instances, the agreement was for the exchange of half a pound or 8 ounces of methamphetamine, which is approximately 224 grams, in exchange for $1,500, which was the going rate for methamphetamine in Hendry County at that time.
Thank you, counsel.
Okay, thank you, Your Honors. Thank you.
Thank you.
May it please the court. First off, there is no evidence here of an express agreement between anybody. We could interpret, if we knew who was speaking, some of the telephone conversations to imply an agreement, but there's no express agreement, no evidence of an express agreement.
Counsel, what's your response to the state's argument that taking the evidence of the calls, but in conjunction with surveillance by law enforcement, photographic evidence, vehicle tracking, that would allow the
Well,
jury to find beyond reasonable doubt?
I'm sorry. The surveillance by law enforcement and the vehicle tracking revealed that vehicles associated with Magana and associated with Cruz were seen at the same place at the same time. I think on 3 occasions. On one occasion, underway leaving a supermarket. On the other 2 occasions, stopped. But nobody knows, and there is absolutely no evidence about what transpired. Some of the witnesses testified affirmatively that they did not see anything change hands, no money, no drugs, no nothing. So we can assume without knowing that 2 people met, they must have been involved in a drug deal, but that's not an assumption that the evidence allows us to make. It would require a stacking of inferences, which, as the court knows well, and as I addressed in the briefing, is not something that's permitted. So we can say vehicles associated with Cruz and Magana were seen at the same time at the same place, but we cannot assume that because 2 people were at the same time in the same place, that they were doing something unlawful.
Do you disagree with the state's argument that the conspiracy charge to be found guilty does not require an actual consummation of the agreement? It just requires the agreement itself.
Well, what has to happen in a conspiracy, the way this conspiracy was charged, was that 2 people agreed, conspired, or confederated to cause trafficking in amphetamines to be committed. So we have to have some evidence that somehow Mr. Cisnero caused trafficking to be committed. Now, the trafficking requires that amphetamines, in this case, be sold, purchased, etc., or brought into Florida in a quantity of over 200 grams. So to be trafficking, we have to have more than 200 grams. To get to that from the evidence requires multiple inferences and multiple instances of stacking. We can say, okay, maybe Magana was part of a conspiracy, but to make, excuse me, to make Mr. Cisnero part of the conspiracy, we have to have some communication in furtherance of the conspiracy. And we don't, for the reasons that I've already stated. One of the things that the state did in this case was write an answer brief which contained a great deal of material that was not in the record. Now, I do not know what or where or how that came from, but I would certainly ask the court not to consider it since it's not in the record. If some opposing party thought that the record was, excuse me, incomplete or there were errors, that party could certainly move to complete the record or to correct the errors. But there's been no such motion in this case. So I think we need to stick to what's actually in the transcripts to decide the case.
Thank you very much, counsel. Thanks to both counsel for your preparation and presentation here. We're going to take the case under advisement. We'll be in recess.
Thank you, Your
Thanks,
Honor.
Chief.